Okay.
Court is now in session. Jessica Fent versus Daniel Fent.
For the record, this matter is before the court for continued pretrial conference subsequent to the parties have engaged in mediation with Mr. Pratt for the front of the court this morning. This hearing is being conducted via Zoom. Present is attorney Lear Worka, representing the plaintiff, Jessica Fent. Ms. Fent is present. In addition, attorney Derek Jocks is present, representing the defendant, Daniel Fent. And Mr. Fent is present. Good morning, everyone.
Good morning, Your Honor.
Good morning, Your Honor.
The court has been informed the parties have reached their own agreement this morning. Is that correct?
That is correct, Your Honor.
Wonderful. Who would like to place that agreement on the record?
I will.
Please, Ms. Worka.
Thank you, Your Honor. The parties have agreed that there will be no spousal support and it is forever barred as to both parties. The marital home is awarded to Mr. Fent. Mr. Fent will pay Ms. Fent $28,500 for her share of equity in the marital home, and that is to be paid within 14 days of entry of the judgment. If it's not paid, the home will be listed and sold, and the proceeds will be divided between the parties. The Ford Escape is awarded to Mr. Fent. Each party will be keeping their own bank accounts and their own debts, with the exception of the Sapphire Resort Vacation Club. That is awarded to Mr. Fent. If there's any documentation that needs to be signed to facilitate that, my client will do whatever needs to be done. There is some personal property that belongs to Ms. Fent that is still at the marital home. The parties have agreed as to what those items are and will make arrangements with a third party, I believe Mr. Fent's father, to coordinate my client being able to retrieve those items. Mr. Fent does have a retirement account. My client is awarded half of the marital portion of his retirement account with any loans included. Valuation will be as of the date of judgment, and my client's share will be adjusted for gains and losses from date of valuation through distribution, and the parties will use Ann Pastrana to prepare any necessary quadro, and they will split the costs associated with that. The parties, for their 2023 tax return, they will file married but separately. Child support will be $691 per month effective July 1st. There is a UCSO that has already entered for child support. For child tax exemptions, mother will claim the child in odd tax years. Father will claim in even tax years. It is our intent that this provision will be considered part of the child support provision of the judgment and is thus modifiable. The parties will share joint legal custody of the minor child. Physical custody and primary residence will be with mother. Mr. Fent's parenting time shall be supervised by the paternal grandparents in their home on Wednesdays from 4 p.m. to 6 p.m. and either Saturday or Sunday from 1 p.m. to 3 p.m. Ms. Fent will coordinate which day of the weekend with the paternal grandparents and communicate that to Mr. Fent via app close. Neither party shall have any significant other or romantic interest present during their parenting time. Father shall not consume alcohol in the presence of the minor child or be under the influence of alcohol during his parenting time. All communication between the parties will be via app close and only regarding the minor child, and plaintiff's maiden name is restored to her if she so elects. And I believe that is the entirety of the agreement.
Thank you, Ms. Worka. Mr. Jocks, did Ms. Worka accurately state your client's agreement?
Yes, she did, Your Honor. Thank you.
Thank you. Wonderful. Mr. and Mrs. Fent, can you both please raise your right hand to be sworn? You need to unmute yourself, Ms. Fent, and is Mr. Fent still present?
I am here. Yes, sir.
All right. I just want to make sure you could hear us on audio. All right. To Mr. Fent, do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
I do.
Thank you. Ms. Worka, you can begin with Ms. Fent, please.
And did you hear the terms of the settlement agreement that I just placed on the record?
Yes.
Do you agree to those terms?
Yes.
Okay. And you understand them?
Yes.
You agree to be bound by them?
Yes.
And do you understand that the terms of the property settlement cannot be changed?
Yes.
That only custody, parenting time, and child support could be modified in the future?
Yes.
And you understand that you are waiving the right to trial in this matter.
Yes.
And you understand that if you had gone to trial, you could have done better, worse, or about the same.
Yes.
Okay. Are you entering this agreement of your own free will?
I am.
Okay. And are you satisfied with my representation?
Absolutely.
Thank you. And Your Honor, I believe we did put proofs on the record previously.
Yes.
But just to update that, Ms. Fenn, are you currently pregnant?
No.
Okay. Thank you, Your Honor. I have nothing further.
Thank you, Ms. Worka. Mr. Jacques, do you have any questions, first of all, for Ms. Fent?
Nothing for Ms. Fenn, Your Honor.
Thank you. Questions for Mr. Fent,
Did you hear the
please?
terms of the agreement that were placed on the record?
Did.
And do you understand the terms that were placed on the record?
Can't hear him.
Mr. Fent?
I do.
Okay.
And do you understand that the terms regarding the property settlement are full, final, and binding?
I do.
Do you believe that the terms regarding property settlement are fair and equitable?
Yes.
You understand? We already did proof, so I guess I'll just leave it at that, Your Honor. No further questions. Thank you.
All right. Thank you, Mr. Jacques. Ms. Worka, do you have any questions for Mr. Fent?
Yes, Your Honor, just briefly. Mr. Fent, have you fully disclosed all of your assets and liabilities throughout this divorce?
Yes.
Thank you, Your Honor. I have nothing further.
You'll prepare the judgment, Ms. Worka?
I will, Your Honor.
Thank you. The court would like to acknowledge Mr. Pratt as well as attorneys Worka and Jacques for helping facilitate ample resolution of this matter. Mr. and Mrs. Fent, without question, the best resolution of matters of this nature is one which you both participate and ultimately agree upon. No question. Keep in mind, you'll not be legally divorced until the court signs written judgment, which perhaps will be within the next couple of weeks. Based, however, on the testimony that's been presented this morning, as well as the complaint filed this matter, the court finds that jurisdiction has been established and that there has been a breakdown of the marriage relationship. To the extent that the objects of matrimony have been destroyed, there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter, granting a divorce from the bonds of matrimony. That will conclude this matter. You can all zoom out. Thank you again, Mr. Jacques and Ms. Worka.
Thank you, Your Honor.
Thank you, Your Honor.
You're
I had a quick question while we're still here. Were we going to receive a review date for the parenting time today, or will that be sent to us at some point in the future?
I think all the council's got to do is reach out to Ms. Frazee, who just schedules things for the courts, unless you want that date in the judgment.
We had discussed placing in the judgment. I'm not sure if that's something you
Okay.
want. Or
What are you talking about? 2 months, 3 months? What kind of time frame is Worka?
I think we would be looking at 3 months.
I'm sorry, 3 months?
3 months, Your Honor.
So you're talking about sometime in May?
That would be our request, yes.
Mr. Jacques, would you agree sometime in May?
That's fine, Your Honor.
Okay. What you give some dates? We'll get
May 7th, that's a Tuesday at 10:30 or 3.
I could do 3.
May 7th
That'll
at 3.
make work.
I'm sorry, Mr. Fent, does that work for you?
Yes, it does.
Okay, you can put that in the judgment then, May 7th at 3 p.m.
Certainly, Your Honor.
Versus Daniel Fent.
For the record, this matter is before the court on the plaintiff's mother's motion to suspend defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Leah Worka, representing the plaintiff's mother, Jessica Fent, and Ms. Fent appears to be present. Is Daniel Fent present on audio? It appears that he is not. This matter was scheduled for hearing at 2:15 this afternoon. It's now 2:53 p.m. Mr. Fent has not appeared. He's not contacted the court. Ms. Worka, Mr. Attorney Derek Jacques advised you that, excuse me, that he's no longer representing Daniel Fent. Is that correct?
That's correct, Your Honor. I did serve Mr. Jacques on the 10th. We had a telephone conversation regarding this case and specifically this motion. He then emailed me the next day on the 11th, informing me that he was no longer representing Mr. Fent, at which time we served Mr. Fent personally with the motion.
Well, the court notes a judgment of divorce was entered on March 13th, 2024. That judgment of divorce did provide for a parenting time review on May 7th at 3 o'clock. Is that correct?
That's correct, Your Honor.
Okay. Simply that since that provision was in the judgment that Mr. Jacques approved on behalf of Mr. Fent, he would continue the case. But if he informs you, and the fact that you personally served Daniel Fent, I guess, makes that a moot issue.
I was also under the impression that he was continuing to represent Mr. Fent because that review hearing was scheduled into the judgment, which is why I served Mr. Jacques by personal service and email.
Correct. And the court file reflects that you served a copy of this motion, notice of hearing upon Mr. Fent by mail. Is that correct?
It was personal service, Your Honor.
Okay.
Which then became a large part of the basis for the addendum to our motion that was filed yesterday.
I'm just looking for that. I do see a proof of service by mail upon Mr. Fent on April 11th. There's also a proof of personal service upon Attorney Derek Jacques on April 10th. When was Mr. Fent served personally?
He was personally served on the 11th by Rich Castora. It is not the SAO form proof of service. Give me just one moment.
I see Mr. Castura did serve personally Mr. Jacques on April 10th. You're saying that same process server personally served Mr. Fent on the April 11th?
That's correct, Your Honor.
Oh, I do. I'm sorry. The court stands corrected. The proof of service does indicate that this was signed by Mr. Castura that he personally served on April 11th. Copy of the motion, notice of hearings and instructions, and ex parte motion to suspend parenting time. All right. All right. The court satisfied Mr. Jacques as well as Attorney Jacques as well as the defendant Daniel Fent received notice of these proceedings. The motions filed by Mr. Work are extensive, alleging that the defendant's behavior and based on the allegations, it does bear the court that his actions are unreasonable, aggressive, abusive, paranoid, clearly suggesting that he's in a state of psychosis. The court has also reviewed affidavits attached to Mr. Worker's pleadings, affidavits from a former girlfriend of Mr. Fent, as well as an affidavit from local attorney Billy Jeffers suggesting irrational conduct on the part of Mr. Fent, whether it's text messages, numerous during the middle of the mornings, clearly suggesting that Mr. Fent is on the brink of a mental breakdown, perhaps exacerbated by consumption of alcohol. The prior of this court did permit supervised parenting time, supervised by the defendant's parents. Ms. Worka, your client is no longer comfortable with that arrangement because the parents seem to believe there's no issue. Is that correct?
That's correct, Your Honor. They have appeared to be very dismissive of Mr. Fent's current mental state. He has been incredibly abusive, aggressive. There is a history of physical violence. His parents have made comments that he's fine, that they essentially, my client feels that they have dismissed all of her concerns, despite the fact that they have been victims of his aggression and violence in the past. They are well aware of his very extensive history. He has been hospitalized for mental health issues in the past. He has had, I believe, 6 different stints in treatment facilities, residential and inpatient, for substance abuse in the last, since 2017. My client is also very concerned that even if they had the very best of intentions, given his erratic and violent behavior, that they would not be able to protect this baby from Mr. Fent.
And the court does note that this child is just 1 year old, and so it is a baby. You're correct, Ms. Worka. When did Mr. Fent last have contact with the child?
I think it was the last week of February.
Oh, okay. So his parenting time now is Wednesdays 4 to 6 and Saturday or Sunday 1 to 3, but it's been some time since late February that he's had any parenting time. Is that correct?
Yes, March 4th is when it was brought to my attention that he was most likely in a state of psychosis. It was very eerily similar to everything I've dealt with from the time I petitioned the court in 2019, and it was approved through Judge Lohmeyer's court. and then all the experiences I had up until last year when we emergency left when I was 8 months pregnant. So I contacted his parents and said I do not feel comfortable for my own safety, but especially for my child's safety, coming to this visit. I let my attorney know, and we've kind of gone from there, but he's become like more and more.
Thank you. Well, you said Judge Lohmeyer. When was the hearing before Judge Lohmeyer? Is that in this February?
Your Honor, she was referring to a prior mental health petition that she filed in 2019.
Prior to the judgment entering?
Yes.
All right, because of course, looking at what's happened since the judgment was entered, but in any event, based upon the court did review all of the pleadings submitted by Attorney Werka. Based on those and defendant's failure to appear, the court will in fact follow the recommendation of Ms. Mayville this afternoon. Court will order that the defendant's parenting time be suspended until further order of the court. Further, that the defendant shall undergo and provide a proof of a comprehensive psychiatric evaluation to the court and to counsel that appears to be appropriate. In addition, defendant shall undergo a complete substance abuse evaluation and provide proof to the court and counsel. And the current review scheduled for May 7th at 2024. Is it possible, Ms. A, put a time in there just for the ease and benefit of Mr. Fent? I believe that hearing on May 7th is scheduled for
3 p.m.
3 p.m. So if they can squeeze that in there, just 3 p.m. after the reference to May 7th. So that will continue, and we'll keep that under the court's docket. Hopefully, Mr. Fent will appear and have some documentation at that time. Anything further this afternoon, Ms. Werka?
No, Your Honor. Thank you.
Right. Thank you, Ms. Fent, for appearing today, and Ms. Werka. Ms. Mayville, I'm sorry to create more work for her. Hopefully you can squeeze it in without having to retype everything. Just putting the time there of 3 p.m. Okay, that concludes, Mayor. Thank you, Ms. Werka, Ms. Fent. Have a good rest of the day.
Thank you, Your Honor. You as well.
Thank you, Your Honor.
Andrews.
For the record, this matter is before the court for continued pretrial conference. Subsequent parties haven't engaged in mediation with Mr. Walker in front of the court this morning. This hearing is being conducted via Zoom. President is Attorney Christina Hills, representing the plaintiff Ashley Andrews, and Ms. Andrews is present. In addition, Attorney Michael Cutler is present, representing the defendant Kenneth Andrews. Good afternoon, everyone.
Good afternoon, Your Honor.
I apologize and thank you for not being here at earlier this morning. I had an event I had to be to. Typically, I'm here until afternoon. So I know things are ready to be called close to noon, but I appreciate everyone coming back this afternoon. The court has been informed the parties made progress, a partial agreement, and wish to continue mediation. Is that correct?
Yes, Your Honor.
Okay. In fact, Mr. Walker has provided the court with the following. Perhaps I can share this first of all with the parties. It appears to be primarily parenting time. And that was, of course, the plaintiff had scheduled for hearing today a motion for a set parenting time schedule. The recommendation is as follows. Parenting time should be week on, week off with exchanges on Fridays after school. The parties should make sure that the minor children are to school on time every morning. The parties shall add any medical, dental, optical, therapeutic, extracurricular, etc. appointments involving the children and other events in the app close shared calendar as soon as they are known. Involving the children and other events in the app close shared calendar as soon as they are known. The minor children's therapist shall determine if in-person or telehealth appointments are appropriate. We'll follow his recommendations. The attorney shall exchange all school, extracurricular, and phone bills that are past due, paid, or coming due within 30 days. The party shall not track the other party during each other's parenting time. The party whose parenting time it is shall not be present or in any way interfere or allow a third party to be present or in any way interfere with phone contact between the other parent and the children. Further, that the mother shall return the minor children's gizmo watch and charger if the charger is in their possession to the father at the next parenting time exchange, which is Friday, February 23rd, 2024 after school. The party that makes appointments for the children shall make every effort to have the appointment scheduled during their respective parenting time. That is the recommendation of Mr. Walker. Ms. Hills, is this recommendation agreeable with your client?
With some clarification, Your Honor, as well as a couple of additional requests. With regard to the clarification, the last sentence that the court read was that the party that makes appointments for the children shall make every effort to to have the appointment scheduled during his or her own parenting time. There is an implied expectation that the parties would share responsibility for making those appointments. The parenting time is 50-50. So there's an expectation of equal effort in scheduling those appointments, and that they would be scheduled on each party's time, as opposed to just one party making those appointments and taking the children to those events. Also, it was previously ordered that the parties shall make sure that the kids get to school on time. There have been issues with that. So with regard to Mr. Andrews, it's our understanding, based on the mediation, that on days when he is not able to see the children onto the school bus, that he would be dropping off the two older children to school on time, and that he would utilize the latchkey program for the youngest child to ensure that they are not tardy or absent. So with those clarifications, we do agree with the recommendation. And then again, I do have 2 additional requests on behalf of my client, but I'd be happy to address those once the court has clarification on whether we have an agreement based on this recommendation or not. And I'm sorry, there is one additional. Mr. Walker ran out of space, but it was also recommended, and he can chime in here if he wishes, that my client have access immediately to the Mesa Health Insurance HSA account for herself and the minor children. That was previously ordered and has not happened to date. So there seems to be no reason why that shouldn't be done immediately.
Thank you, Ms. Hills. And of course, if the court adopts a recommendation, you can certainly prepare a formal order if you wish that incorporates and expands upon some of these things. So certainly, by implication, those are all appropriate. Mr. Keller, is this recommendation agree with your client?
Only in part, Your Honors, and I'll explain. The current situation of the parties are exchanging the children on Tuesday, week on, week off. It was our understanding that mother requested the change from Tuesday to Friday. We were never told that father would be deprived 11 days with the children. So we thought, and that was never told to us, that it would be this coming Friday. Since mother made the request, we understood she was willing to switch it to Friday to accommodate her reasons. We had no objection with that. But we were never told it was going to be a week from this Friday. And I expressed my objection of that to Ms. Hills. Apparently, mother doesn't care what day it is, whether it's Monday or Friday. So I suggested, in order to avoid either parent being deprived time with the children, that, of course, next Monday is a holiday, so just continue on Tuesday, and then there on out, it would be every Monday. That the exchange would occur at the school, as opposed to being at the police station where it usually was in the past. So I expressed my concern with that. I spoke to Mr. Walker. I think he'll agree that he did not indicate to us, if we agree to Friday, that it had to be a week from this Friday and depriving dad parenting time. I did offer alternatives to Ms. Hill, saying, if father's going to be deprived these 3 additional overnights, why don't we make it equalize it, give him a couple additional days during the upcoming holiday or some other occasion. Unfortunately, I did not receive any traction on that. So one is the Friday date in order to avoid any conflict for either party to lose precious time with the children. I'm suggesting Monday. I would also indicate that we were never told about this access to the HSA. That was never an issue brought up in our room. I know the parties are attending mediation in a short period of time. This will be private mediation. We can discuss that and other issues that we have also addressed during our discussion, including father having access to certain codes and passwords, which are in mother's possession that she does not relinquish. As far as the last issue, on time, it's my understanding that both mother and father are having issues having the children to school on time. We would think both would do their best to make sure that they are not tardy, that they're not late and not missing school. And there was no agreement about utilizing latchkey. In fact, what was discussed in our room with Mr. Walker was that either party could use latchkey or a after-school tutoring program if they wished. And if they did exercise that program, they would be responsible for the cost. but neither party would be required to use it because the children have a number of activities and they have other obligations. That's how it's described to us, Your Honor.
All right. You indicate that there's another mediation scheduled, Mr. Cutler?
It is. It's scheduled for April. Remind me, counsel. I think it's April 17th. I think.
April 22nd with Mr. Godfrey. And Your
I'm
Honor,
hoping that everything gets concluded at that point through the private mediation.
What time, April 22nd, Ms. Hills?
I believe we're starting at 9 a.m.
All right. That's just about 60 days off. Mr. Godfrey is very good at what he does. So, Ms. Hills, I guess with respect to the HSA health account, is that critical right now? If in fact Miss Mom incurs an expense, I guess she can just pass that expense on to Dad if Dad's been paid out of the HSA account. Seems like it's sort of cumbersome. I mean,
they've traditionally paid all the medical expenses out of that account, and she's always had access, particularly to her own information. But she's cut off from all information regarding health insurance and explanation of benefits and that sort of thing, as I understand it, with regard to the children as well. I think she has a right to see those things, and the court did previously order it. It's just not been complied with. So I don't know, I take Mr. Cutler at his word that didn't come up in their room, but it already is a court order. We're just seeking enforcement of that. With regard to the exchanges,
I'm sorry, Ms. Hills, on that issue, does Ms. Andrews need a card? Has the account number been changed or something so Ms. Andrews can't use it?
No, not to my knowledge. Is that correct, Ms. Andrews?
I have access to the HSA savings account, but there are no funds available to pay any of the medical bills out of the HSA account. And I do not have access to any of the EOBs through MESA.
So, Your Honor, it sounds like she has access, so it sounds like the prior order was complied with. The fact that there's no money is because it's been used up. That's through his employer.
Okay.
Your Honor, if I may address the exchange for parenting time. We came about the Friday. It wasn't necessarily my client's suggestion. Mr. Walker had expressed some concern about exchanging the children in the middle of the school week and how disruptive that was. And that certainly is a good point. So we discussed different alternatives, and my client did like the idea of exchanging on Fridays. However, we didn't discuss initially when it would start. My client already had a pre-planned weekend up north with the boys to see their grandfather. And so that we discussed the start date when we were putting the final touches on Mr. Walker was putting the final touches on his recommendation. So that's how that came about. There was no intent to deceive or play games or anything along those lines. If we were to exchange on Mondays, that's still disruptive to the children's school week. My client has indicated to me that with regard to those 3 overnights of parenting time that Mr. Andrews would currently be deprived of, she's been denied a number of other overnights of parenting time and days of parenting time over the last couple of months. However, perhaps the easiest thing would be we would ask the court to adopt the recommendation and simply reserve those 3 overnights to be addressed at mediation with Mr. Godfrey.
Your Honor, if I can just quickly touch upon that. Father's also indicated that he's been deprived parenting time, but I don't want to go down that road. I'd like to address that during the mediation that we have scheduled. As far as disruptive, it's a drop-off at school. If they are currently utilizing Tuesday, 1 day off is a lot less disruptive than the end of the week being the exchange time. So I don't understand if that's the concern about disruption for the children. If they're dropped off at the beginning of the week and spend the entire week with one parent, that seems to accommodate all the concerns. I'm not sure why that's a problem, but if it is a problem, I guess we can continue to use Tuesday until we go through mediation. So we didn't ever agree to have mom have the children for a whole 11 days and father not seeing them at all until a week from this Friday.
Very well, the court believes that right now the parents are exchanging at a police station. Is that correct?
Correct.
The court believes that the most appropriate place to change is minimize contact between the parents, and they can exchange at school. So either the court believes that exchanging during the week is disruptive for the school. So the court believes the best time to exchange is after school on Fridays, Mr. Cutler. So I don't know if we change the Fridays. Of course, inclined to simply adopt this recommendation, Mr. Cutler, and the court will reserve any request to make up parenting time by either party. The court notes for the record that Mr. Andrews is being deprived 3 overnights. We will address that. The court will reserve that. Subsequent to, and if parties cannot work that out mediation, the court will address that after mediation, because the court's going to schedule another pretrial conference immediately after this on April 22nd mediation. With respect to the authorization or access to the HSA health account, Ms. Sills, there's nothing in it. So I guess, obviously, I guess the court can order that Mr. Andrews, if he's not going to give Ms. Andrews access to the OBs, and he's ordered to provide copies of all that to Ms. Andrews.
Fine.
Print out all the hard copies. You can go online. Very often they're online now. He can print them off whenever there's a medical appointment made and provide those to mom. How are they right now sharing uninsured medical expenses? Is there an order that provides for a percentage?
No, I don't believe there is.
Okay.
I don't believe there is either. I would defer to my client. I know Mr. Cutler's even newer than I am, and there have been a lot of orders that have been put in place prior to us being on the case.
HSA account has been what has been used, which is out of my paycheck, out of my employer. This is Ken speaking.
Okay.
So 100% of it's been out of me.
Okay. Are the incomes, is there a disparity in income? Are they relatively equal?
There is a disparity in income, Your Honor, and an issue regarding what Mr. Andrews' income should be considered to be based on a previous loss of employment.
We also have some concerns, Your Honor, regarding mother's income, things that I'm investigating at this point. Again, I expect us to make headway on this and present it all during the mediation process within the mediation summary, and hopefully we can bring it all to conclusion. My client would like to have this wrapped up during that session.
All right. The court's confident too. Ms. Hills, the prior order for the HSA account, did it order that Mr. Andrews continue to fund that?
Not to my knowledge.
All right. All right. So the court can reserve that issue. We can reserve that issue about the, yes, Ms. Andrews.
I would like to state that all marital assets and liabilities, marital status was to remain status quo. And as of September 8th, that was the last contribution into the HSA account, where that has been an ongoing contribution for numerous years throughout the lifetime of our marriage.
Okay, well, that's noted. Are there any current outstanding medical unpaid expenses?
Yes, Your Honor.
Okay. Approximately how much? You're talking about a couple $100s or?
We're close to 1,000. We have a high yield deductible that starts over as of January 1st. And so once we hit that high yield deductible of $2,500, then our medical expenses are covered for the remainder of the year. We tend to hit that high yield deductible between April and June of each year. Our HSA account has always been pre-funded for the following year, as the contributions have always gone in. I do have documentation to provide and show forth to the court of those deposits into the HSA account that normally come out of the employer's, out of the check from the employer.
So, Your Honor, I haven't seen these documents. If they have them, it'd be great if they exchange them. I know part of our agreement is to exchange some of these bills and records, including children's related extracurricular activities, school bills, and other things of that nature. If we can have some of this information, I'm sure counsel and I can review them and go through it. I don't know any reason as to why the my client is essentially a state employee. I don't know why something may have been restructured, but we'll get to the bottom of it. It's the first time I've heard about it today. It would have been nice if I had some time beforehand.
Well, if the status quo order has not been modified, then it appears to the court, and we'll reserve that issue, but it appears to the court that Mr. Andrews should continue to contribute to that HSA account as he has in the past.
Understood. And I Don't know if he's made a change or if something changed within the system. I'll have to find out. And I certainly will advise my client that any order of the court needs to be followed per the T, per the dot. Everything needs to be applied to. So I will certainly investigate into that.
All right. Thank you, Mr. Cully. We don't obviously want medical providers turning away this family and saying, well, you got unpaid bills, so we're not going to treat your children or whatever. So yes, Mr. Cully, if you can discuss it with your client, the clerk, if that staff order has not been modified, then the court would expect that Mr. Andrews would continue contributing to that HSA, at least to take care of these existing outstanding debts, medical bills. So Ms. Andrews, perhaps you can provide those to Ms. Sills, you can provide them to Mr. Cutler, and to the extent that they're not resolved, the court will address that after the mediation on April 22nd, 9 a.m.
Your Honor, I'd just like to say one thing. You know, there is money and there was money in there, but if you look at the most expensive thing that you can do is take your children to emergency care, and that has been her practice recently. So that has drained that account, and a lot of those practices, instead of having, you know, making your doctor's appointment and doing it the correct way, she is using that, which has completely drained that account. So of course there is no money in that account if you're not using it appropriately. And ever since July, you actually told us at July that we should separate our funds, and that's what I have done. If the average divorce is 6 months with kids and we're 13 months in, what was she going to do for employment? It's very confusing for that. So,
all right, you're both represented by two very capable family law practitioners, and the court believes that with your assistant attorneys, you can work through those issues together. Mr. Godfrey is very capable, and the court's confident that he will be able to make progress in helping the two of you reach your own agreement, which is without question the best resolution is one in which you both participate. Far better off than this court making these decisions. But if we don't have a resolution after the mediation April 22nd, the court will schedule a trial date so as to finalize this matter. But at this point in time, the court will adopt Mr. Walker's recommendation. Mr. Andrews has a planned weekend exchange with his parents on the weekend of after February 23rd. Is that correct? So he wanted, because this parenting time for dad will start February 23rd after school. And he has something that weekend, correct, planned?
No, it was mother that had it this weekend.
It was mother's reason for wanting not this Friday to be exchanged, but to be next Friday. She claims she has something between those dates.
Well, it would make any difference if we go to beginning on Friday, March 1st? Is that going to make a difference?
Well, that would mean that father wouldn't see the children for 18 days straight. Yeah. So we certainly don't want that to happen.
All right, I understand. So the court's going to adopt the recommendation. The exchange for dad will occur after school Friday, February 23rd. The court will reserve any overnights, whether it's 3 or more overnights, to dad. And of course, if there's any parenting time as due to mother, the court will address that at mediation. If it's not resolved by Godfrey, the court will address it at that time. And Ms. Sills, if in fact you want to expand upon to clarify some of these points, you can do that in order. I think this order does cover everything.
We'll do that, Your Honor. We did have 2 additional points.
Okay.
If I may at this time.
Please.
The 2 older children, Garrett and Colin, are struggling mightily in school right now. Each is getting 3 E's in different classes, including each of them in math. My client has engaged the children in a homework help program after school, and she has the kids going at least 3 afternoons after school each week on her weeks. The cost is only $2. It's 1 hour, $2 per child, 1 hour of help with homework and tutoring. And we are requesting that under the circumstances with the children's grades being what they are, that Mr. Andrews make use of that program as well. As I indicated, it's only $2 per child per hour, but my client is willing to foot the bill for that as well, if that makes any difference whatsoever. But it certainly seems appropriate that the children get that extra help available at such a reasonable cost. It is my understanding that Mr. Andrews would have the ability to pick the children up after that program was over. So I don't know of any reason why we couldn't take advantage of that for these children who are struggling academically.
How many days per week?
She's doing 3. Is it 4 days total that it's available, Ms. Andrews?
It's available 5 days a week, but I don't want to overload the children with any extra activities that they may have. So 3 days a week, I believe, is sufficient in maintaining their and assisting with their grades.
Okay, and what days of the week?
So we've been doing a Tuesday to Tuesday schedule. It just depends on what days are efficient for the boys. Within the week that I have them, I request them to go 3 days a week and I pick them up from school.
What days would you take them?
They
Tuesday,
attended
Wednesday, Thursday?
Sometimes it's Wednesday, Thursday, Monday. Sometimes it's Tuesday, Wednesday, Thursday. It just depends on what projects that they have during the week and what they need additional assistance for. But as long as they're going 3 times a week, they're getting that extra hour of academic support.
How many hours per day? Just 1 hour per day?
1 hour per day.
So you're talking about $6 a week?
Yes, Your Honor.
All right, Mr. Cutler, any reason why Dad couldn't continue that when the children with him, that he provide the homework health program 3 hours per week?
Well, the problem is, Your Honor, once again, this was never brought to my attention. No email, no information. We don't know anything about this program. I'm sorry?
The court's going to order it. The court's going to order it.
I understand.
Again, if you want, you can talk with Miss Hills again. I can put you in a breakout room. You got time staff and you can talk about it, but it seems that for $6 a week, there should be some consistency, continuity. So, but I'll let you talk with Miss Hills, but the court's inclined to order, Mr. Cutler. Do you want to talk with Miss Hills further about it?
No, Your Honor, I was hoping to get actually the program. Maybe she could send me, I asked before, a link to this program so we can find out about it. I don't even think opposing counsel was really aware what program it was, so maybe her client can advise her and that information can be passed on. We certainly want to make sure the children receive appropriate education and appropriate tutoring. We just need some investigation to find out where this is and what it is, so he can make an agreement.
That's appropriate and reasonable, Mr. Cutler. Thank you. Ms. Hills, can you provide that information to Mr. Cutler forthwith?
I believe that Mr. Andrews is aware of the program that the children are in, but yes, absolutely.
Okay.
He is not, Your Honor. But that would be great.
All right. So if you can get the information, pass it on to Mr. Cutler so you can review with Mr. Andrews. And yes, the court would order that. Mom, you continue. That's important. Obviously, the education of these children are very important. So yes, the court can order that each of you provide 3 hours per week. And then the same makes sense for the to be consistent continuity that it's 1 hour per day. Ideally, if you could agree upon a date, but again, if it's dependent on what other activities the children have, I'll leave that to the parent in whose possession the children are in at that time, that week, whether it's Monday, Wednesday, Friday, Tuesday, Wednesday, Thursday. I'll leave that up to each individual parent. But the court will order that to begin forthwith. Ms. Hills, something else?
Yes.
Excuse me.
I'm sorry.
I was going to say she uses it for daycare, or she uses it more for her transportation purposes. So unfortunately, I use the school transportation to and from school. That's the reason why I moved into the district. If I didn't move into this district, I would have saved at least $400 a month in my rent. You know, so that I find that very restrictive, and on my rights as a parent. I understand the value of it, but I also need that transportation to get my kids to and from school. So there's the double-edged sword of that.
This court's only concern is the children.
Right. And that the transportation of the kids would be, if that's a struggle for me to get to and from, I find it very restrictive. I do.
Okay. What hours is this program? It's immediately after school, Miss Andrews?
That is correct. It runs from 2:20 p.m. until 3:20 p.m. And on 10/23/2023, Mr. Andrews and I had communication regarding homework help through AppClose.
But Your Honor, I think my client's point is that he utilizes the bus system, and by mother requiring this, and certainly maybe father can have a different option. Possibly he can utilize his own tutoring for the children. Possibly he can have somebody come to the home to tutor the children. And because he needs to utilize the busing system for his employment, I think that's the point he's making.
Okay. Right. And what happened is that the kids started youth wrestling after practice, and there was a duration of time, like an hour and a half. And to fill that time, this is when she came up with this. So this would be her daycare, if you will. So she didn't have to do the transportation and take the kids to practice. That's how this originally came about.
The academics is more important than sports at this point. If they're failing classes, this education and additional help on their homework, it takes precedence over wrestling or any other activity they're involved in. So, do you have any family members, Mr. Andrews, that can assist and pick up the children at 3:20 or 3:30?
Oh, of course, but
okay.
Yeah, what's frustrating about it is that she put a court order against me originally.
Hold on, Mr. Andrews. Hold on, Mr. Andrews.
Thank you.
So, Your Honor, if my client can use third parties to pick up the children from school and bring them to his home, it sounds like he can accommodate their after-school program. It's certainly a low price. If it is a benefit, obviously everyone wants to utilize anything they can for the children's benefit. If that's not an issue, then I'm sure it can be accommodated.
All right, thank you. Ms. Hills, is there a problem with that?
I don't believe so. Ms. Andrews, do you have any issue with any third party that the children know picking them up after the school program?
I do not.
Okay.
Mr. Andrews, who would you propose? Your parents live in the area? You got a sibling?
Oh yeah, I could have a brother, 2 brothers. I have a sister-in-law. I have a father. So yeah, there's plenty of responsible adults that the kids are very aware of who they are to pick them up. Yep.
Your Honor, as an accommodation, I'll speak to my client. He'll have to speak to these people within, I'm sure, a week. I can send an email to opposing counsel, indicate a list of individuals who may be able to do this. Obviously, they will all be licensed by the state of Michigan to operate a vehicle and have a functioning vehicle of some form. There's the basic requirements.
Thank you, Mr. Cutler. All right, so did that address that, Ms. Hills?
Yes, Your Honor, thank you. Final issue is with regard to the minor child, Colton. He has expressed to my client, who has in turn expressed to Mr. Andrews, that he is uncomfortable with being left alone with his older brothers, who are very physical with him, according to Colton. He is much smaller than they are, and it makes him very uncomfortable that they treat him as physically as they do. So my client is requesting that the 2 older children, or neither of the older children, be left to essentially babysit Colton, who's 11, because again, it does make him uncomfortable with the physical treatment.
Your Honor, we never heard this before. We deny it entirely. The older children are over the age of 12. My client's never witnessed anything of that nature. And all the children, unfortunately, in this situation, like most divorces, they're all trying to use the parents in some ways to manipulate things. That's where we believe this comes from. This is entirely a creation of mother and without any support at all. To put that additional burden on father to sit there and to have somebody there and present incur the expenses, I don't think that's necessary. There's never been an incident of any violence that we're aware of whatsoever, but I'm sure we will address these issues in mediation.
All right, obviously boys will be boys, and obviously both parents should instruct older boys, don't pick on your little brother. I mean, that's his parenting skills. I mean, obviously it's easier for the bigger brothers to, they're bigger, to pick on an easy target, their younger brother, and both parents should simply instruct the older ones not to just leave Colton alone. I think that should be adequate, and both parents should, if they're aware of it, make sure you tell the older boys that. Don't just, if they want to wrestle with someone, they can wrestle with their dad. They just back off and don't assault Colton. If it becomes an issue, we can address it later on, but at least to brought to everyone's attention, Ms. Hills.
Thank you.
The court will mail out a notice for the parties to appear for a continued pretrial conference subsequent to the April 22nd 9 a.m. mediation with Attorney Godfrey. And again, as previously stated, the court will adopt the recommendation for today. So the parties will exercise week on, week off at Fridays after school rather than at a police department. It's better at school for the children. And the dad's parenting time will, of course, start then the Friday, February 23rd week from tomorrow. All right. Again, Mr. and Mrs. Andrews, you're both represented by 2 very capable law family practitioners. Follow their advice and work to these differences. You got 3 children that you need to raise together and be on co-parent. So with that, anything further than Ms. Hills or Mr. Cutler?
Your Honor, I just asked that Ms. Hills could just send me the proposed order in stipulated form so I can look at it as opposed to just submitting it under 7-day rule. I'd like to work, if there's any additional language, I'd like to be able to discuss it with her and work through those, but I don't think it'll be a problem.
That's no problem. I don't like 7-day ruling orders and only do that when I feel I need to. I'm not there certainly yet with Mr. Cutler. My client is raising her hand. If I may ask her if she has something else.
Certainly.
Yes, I'd like to add, I have completed the high conflict solutions course for co-parenting. As Christina, as we have discussed, if you could make a recommendation for that further in the court, I would appreciate that, for that to be ordered as well. And then, yeah, that's what I have.
Did the court previously order that, Ms. Hills?
The court did not order it. It's something that I had suggested for my client based on my experience with this court and the nature of how this case was going when I first became involved. It has not necessarily improved since then, although I'm hopeful now with Mr. Cutler involved that things will be on the right track. But I certainly don't think it would hurt for Mr. Andrews also to participate in the conflict solutions course. That is not something that I have spoken with Mr. Cutler about at all, or made him aware that that's something that this court fairly routinely orders in high conflict cases.
All right.
Your Honor,
you can pass that information on to Mr. Cutler, and if necessary, yes, if in fact there's issues still existing between these parties, the court would order both parties to do that, and generally require both parties to provide a 100-word essay to this court in terms of what they learned from the class. But at this point in time, the court's not going to order it for Mr. Cutler. I'm sorry, for Mr. Andrews. But if you could pass that link on to Mr. Cutler, he can look at it. And I'm sure if Mr. Cutler please, it would help his client, he will suggest to his client to take that. But the court will not order it this time. But certainly that is a legitimate issue that the court would in fact order if there's still if the conflict between these parties does not diminish. So I don't know if you're familiar with that program, Mr. Cutler, but we can take a look at it once Ms. Hill sends you the information about it.
I think I was familiar with it a while back, but I probably need a refresher as to its current status. So I appreciate that.
No, and I found that it does help parents. It does help parents in terms of looking at things differently and just reducing the conflict for the benefit of the children. So the court would certainly encourage it. Mr. Andrews, I'm not going to order it at this point in time. The court would certainly encourage it. Mr. Andrews, did you feel it was worth your while?
I did, Your Honor. I actually had positive feedback from it, and I learned quite a bit. There was actually information and videos from the children in there that I felt would be beneficial for my children to see from a child's perspective going through divorce, and I have shared those learning points with them as well.
Okay. I always like to get feedback. I don't want to order someone to engage in a program that is not worth their while, but thank you for that input. Right. Anything further than this afternoon, Ms. Sills or Mr. Cutler?
No, thank you.
Thank you.
All right. All right. Thank you both. That will conclude this pretrial.
Thank you.
You can zoom out.
Yeah, it sure was. Wow.
Yeah, I'm glad I didn't do that at 11:15.
And that was an agreement? Yeah, partial. 2:30.
Okay, you want to call it over here?
Urbans versus Charles Mason.
The record, this matter is before the court in order to show cause directed to the defendant Charles Madison for failure to pay a filing fee, $255 filing fee, which he was ordered to pay on or before February 17th, 2023, over almost a year ago. That was provided for in the judgment of divorce entered by this court on December 12th, 2022. The mailing of this notice of this order to appear to Mr. Madison was not returned as being undeliverable. The matter was scheduled for 2:30 today. Since it has not been paid, the court will issue bench warrant for his arrest. Bond will be $255 cash only.